Regardless of your motivation for working, we expect that you would like to be treated fairly and with respect in the workplace. You want an equal chance to get interesting and challenging jobs, promotions, and ultimately the bigger paychecks that come with those opportunities. The employees you manage or currently manage want the same things. Let's take a look at an introduction to equal employment opportunity. Equal employment opportunity, known as EEO, is the term we use to describe the laws, regulations, and processes related to fair treatment of employees. EEO laws and executive orders are intended to eliminate discrimination in the workplace. Discrimination means treating people differently. We choose to treat people differently every day. Discrimination becomes problematic when people are not treated fairly because of a particular characteristic they possess that has nothing to do with their ability to perform a particular job. EEO laws exist on the federal, state, and local levels and are created following the same basic model as other laws, shown here. This figure provides a simple overview of the process leading to the passage of an EEO law and what happens following the passage of the law. Two regulatory agencies oversee compliance with equal opportunity regulations: the Equal Employment Opportunity Commission, known as the EEOC, and the Office of Federal Contract Compliance Programs, known as the OFCCP. The Equal Employment Opportunity Commission, or EEOC, is the agency responsible for enforcing compliance with anti-discrimination laws such as the Civil Rights Act of 1964, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. The Office of Federal Contract Compliance Programs, known as the OFCCP, is the agency responsible for developing guidelines and overseeing compliance with anti-discrimination laws relative to executive orders. Non-compliance with anti-discrimination laws and executive orders can lead to negative consequences, including fines to the organization and charges of discrimination that result in costly, time-consuming legal battles. The demographic characteristics that cannot be used for employment decisions are known as protected classifications or protected classes. The main protected classes are race, sex, religion, color, national origin, age, disability, veteran status, pregnancy, and genetic information. The U.S. Equal Employment Opportunity Commission, or EEOC, enforces federal laws prohibiting protected class employment discrimination. These laws protect employees and job applicants against employment discrimination when it involves the protected characteristics we just explored. A modeling agency has a client that designs clothes exclusively for women. The agency decides to hire only women to model the clothes. The employer in this example would claim that gender, the term we will use interchangeably with sex and the more common term used now, is a bona fide occupational qualification, or BFOQ. A bona fide occupational qualification, BFOQ, exists when a protected classification can legally be used to make an employment decision. The modeling agency could argue that it can give preference in hiring to one gender, female, over the other gender, male, because of business necessity. A business necessity is an employment practice that has some relationship to legitimate business goals that is essential to the company's survival. In our example, the clothing designer focused on women's clothing and needs to sell the clothes to buyers looking for women's clothing to stay in business. Gender, therefore, would be an acceptable BFOQ in this case. The general guideline accepted by the EEOC and the courts to determine the appropriateness of a protected class as a BFOQ came from a landmark 1971 case in Diaz versus Pan American World Airways. In summary, an employer can sometimes make a case that gender, religion, national origin, or age is a BFOQ. The likelihood of successfully doing so, however, is usually very low. Employers can never use race or skin color as a BFOQ. Disparate treatment is treating individuals differently in employment situations because of their membership in a protected class. Most people think of discrimination as being obvious and intentional in nature, occurring when a protected classification is used as the basis for an employment decision. Not hiring a qualified woman simply because she is female would be obvious and intentional discrimination. If someone is turned down for an employment opportunity and can show that it was because of a particular attribute that's protected by law, that individual has the right to file charges against the employer. This type of discrimination is known as disparate treatment. In disparate treatment cases, an individual is treated differently because of the characteristic that defines the protected class. Disparate treatment also means that a company intentionally discriminated against a person or persons because of the characteristics, and a BFOQ for that characteristic does not exist. An employee who believes that he or she has been the victim of a disparate treatment must make a prima facie case or preliminary case using the McDonnell-Douglas test, named after the McDonnell-Douglas Corporation versus Green 1973 U.S. Supreme Court case that identified this four-step process. To make a case for disparate treatment, the plaintiff must show all of the following: that he or she is a member of the protected class, that he or she applied for the job or other employment opportunity, such as being eligible for a raise or promotion and was qualified, that he or she was rejected, and that someone else got the job or the employer continued to seek applications from individual within the plaintiff's qualifications. If the plaintiff successfully makes a prima facie case, the burden of proof then shifts to the employer to provide a legitimate, job-related reason for the decision. For instance, the employer might show that the person selected had more relevant experience or performed better on selection measures. The courts have been clear that even though the employer may have had job-related reasons for a decision, if a protected class membership played any part in the outcome, discrimination has occurred. In other words, a mixed motive has affected the outcome. A legitimate reason for an employment decision exists, but the decision was also motivated by an illegitimate reason, such as a membership in a protected class. Disparate treatment refers to intentionally unfair and illegal treatment of a particular individual. But discrimination may also take a more subtle and usually unintentional form known as disparate impact or adverse impact. Disparate impact is discrimination that occurs when an employment practice results in members of a protected class being treated less favorably than members of a non-protected class, even though discrimination was not intentional. Disparate impact occurs when a company uses an employment practice that unintentionally discriminates against members of a protected class. For example, a job requirement at a home improvement store might state that all employees must be 6 feet tall to perform a job that requires regularly reaching up to obtain items from high shelves. This job requirement might not be intended to discriminate against anyone. It may, however, lead to discrimination against several protected classifications, including females and members of some minority groups. A useful way to think about the difference between disparate treatment and disparate impact is that disparate treatment focuses on the treatment of a particular person or group of persons within a protected class, and explicitly considers the motivation for the company's action. Disparate impact, on the other hand, focuses on the consequences of the employment practice. The court case that identified disparate impact as discrimination was GRIGGS versus Duke Power Company, decided in 1971. At a Duke Power generating plant, black employees challenged the employer's selection requirements. Specifically, to be hired for or to be transferred to other jobs at the plant, applicants had to possess a high school diploma and pass 2 professionally prepared aptitude tests, selection requirements not designed to measure ability to learn a particular job. Also, prior to the passage of major civil rights legislation in 1964, the company had a history of discriminating on the basis of race, even to the extent of restricting black employees to the lowest level jobs within one department and paying them less than the lowest paying job in the other 4 operating departments. In reviewing the case, the U.S. Supreme Court held that the company had not intended to discriminate. However, the selection criteria resulted in discrimination. The relevance of the criteria was suspect because there were employees doing just fine in the jobs in question who did not have a high school diploma and who had not taken the tests. Also, Blacks in the area were less likely than whites to have a high school diploma and would be less likely to pass the tests because of their lack of education. The employer could not show that having a high school diploma and passing the tests were necessary to be able to perform the jobs. Thus, discrimination occurred even though it was not the company's intent. The issue of disparate impact is whether the employer can show that there is a valid, job-related reason for using the selection criterion that discriminates. In establishing selection criteria, or deciding who gets raises or promotions or training, managers need to think about the possible outcomes of their choices. Unintentionality is not an acceptable defense in disparate impact cases. Most importantly, using non-job-related criteria for making such decisions ultimately affects the success of the organization as it rewards the wrong behaviors and attitudes. To make a case for disparate impact, the plaintiff or employee must first demonstrate that the outcome of the employment practice was less favorable for his or her protected class than for the majority. The 4/5 rule is a guideline generally accepted by the courts and the EEOC for making such a prima facie case of disparate impact. A cautionary note is in order here. As a manager, you should not try to hire by the numbers. A manager should not simply calculate how many minority group members need to be hired and hire that many to be in compliance based on the 4/5 rule. Harassment occurs when employees are subjected to unwarranted and unwelcome treatment because of their race, color, religion, sex, national origin, age, disability, or genetic information. Harassment can include, but is not limited to, offensive jokes, unwelcome comments related to a person's protected class, graffiti targeting the protected class, and physical threats. Because of the harassment, employees experience a hostile work environment. A hostile work environment exists whenever an employee is subject to unwelcome harassment because of his or her membership in a protected class and the harassment is severe and abusive. Managers are agents of the company and have the responsibility for implementing the company's guidelines. Retaliation occurs when an employer takes an adverse action against an employee who has filed a discrimination complaint. Retaliation is often a punishment or threat of punishment because an employee exercises the rights provided under the anti-discrimination laws. Retaliation can take on many forms, including but not limited to the following: denying a promotion to the employee who's otherwise qualified, demoting the employee, suspending the employee for a period of time, writing a negative evaluation of the employee, and/or threatening the employee if a complaint is not withdrawn. Develop and regularly communicate anti-harassment policy to all employees, providing examples of the behaviors that would be considered harassment. However, prior to 1963, employers frequently considered gender and marital status when making pay decisions. It was not uncommon for employers to pay males more than females, particularly if the males were married. Newspaper advertisements often had separate listings for male and female jobs, and companies routinely reserved their higher-paying jobs for males. The assumption was that males were the primary breadwinners for their families and needed to make the most money. Even when males and females performed the same jobs, males generally received higher pay. In 1963, Congress made it clear to employers that such pay differences were no longer acceptable when it passed the Equal Pay Act as an amendment to the Fair Labor Standards Act. The FLSA of 1938 had established general guidelines for employee pay, but the EPA specified that gender could not be a factor in paying employees. Today, if a male and a female in the same company are performing the same jobs that require substantially equal skill, effort, and responsibility, and have same or similar working conditions, the law requires the employer to pay them equally. Pay differences for employees in the same job are allowed if they're based on merit, seniority, quality or quantity of production, or another non-gender related factor, such as night shifts versus day shifts. It's up to the employer to prove that the stated reason for a pay difference is an allowable affirmative defense. In 2015, females were earning only 79 cents for every dollar males were earning, according to research by the American Association of University Women. Females 1 year after college graduation were making 82% of what their male peers were paid. Additionally, females, followed for 10 years after graduation, were earning only 69% of what males were earning. Even after taking into account such factors as occupation, hours worked, and parenthood, 25% of the pay gap was still unexplained, suggesting that gender differences may be affecting the outcome. Congress passed the Civil Rights Act of 1964 to address the societal and economic need for change. The passage of the act sent the message that the time had come to abolish discrimination in employment and other areas of society. Title VII is part of the Civil Rights Act that specifically addresses employment discrimination. Title VII prohibits employers from discriminating against any individual on the basis of that individual's race, color, religion, sex, or national origin. Employers with 15 or more employees, including federal, state, and local governments, employment agencies, and labor unions, have to abide by this law. Also, the law covers U.S. citizens and legal residents of the United States who are working for U.S. companies in other countries. Title VII states that it's against the law for an employer to discriminate with regard to selection, termination, compensation, terms and promotion or transfer, work assignment, and any other activity related to employment. As a manager, you need to make sure you're aware of anti-discrimination laws and that you treat all employees fairly. Note that the law applies to employment agencies, labor unions, as well as private employers. Remember that the law does permit the use of religion, sex, and national origin as BFOQs, but only when necessary for the normal operations of a business. As part of the Civil Rights Act, Congress created the EEOC to provide oversight of Title VII for all covered entities except the federal government. The EEOC has developed and continues to develop regulations and guidelines to help employers and employees interpret Congress's intent of the Civil Rights Act. It provides a very informative website at www.eeoc.gov and numerous other resources to answer questions managers have about equal employment opportunity. The EEOC is involved in interpreting the meaning of the term discrimination, determining how individuals can prove that discrimination has occurred, identifying what remedies are available in the law, and addressing how to reconcile seniority rights of current employees with the rights of victims of discrimination. Congress amended the Civil Rights Act in 1972 by passing the Equal Employment Opportunity Act. The amendment broadened coverage of the Civil Rights Act to state and local governments, as well as to public and private educational institutions. The act also gave the EEOC the right to sue employers to enforce the provisions of Title VII. Discrimination based on skin color, also known as colorism or shadeism, is a form of prejudice or discrimination in which people are treated differently on the basis of social meanings attached to skin color. However, in 2013, the EEOC reported that the number of race-based harassment charge filings had increased from 5,783 in 1997 to 9,286 in 2015. Also, in 2015, the EEOC received 31,207 charges of race-based discrimination and resolved 31,782 cases. Cases carry over from one year to the next, with monetary benefits of $88.4 million for plaintiffs. The last figure does not include monetary benefits included in litigation. Under certain conditions, plaintiffs can file charges in court but may receive additional monetary benefits. Employers violate Title VII when they use race itself or race-related characteristics and conditions to make employment decisions, tolerate the harassment of employees because of their race or color, segregate or classify employees based on race or color, or collect pre-employment information about race in such a way that it's available to those making hiring decisions. The following are examples of race and color discrimination by employers in violation of Title VII. Using race or race-related characteristics and conditions to make employment decisions. A no-beard policy may discriminate against African American men because they're predisposed to a medical condition that makes shaving difficult. Selecting only light-skinned employees because they best fit the preferred company image is discrimination on the basis of skin color. Tolerating the harassment of employees because of their race or color. Permitting racial slurs and racist graffiti creates a hostile work environment. Making derogatory remarks about an employee's skin color and then firing the employee for complaining to management is a violation of Title VII. Segregating or classifying employees based on race or color. Assigning racial groups to work only in areas where the customer base is predominantly of the same racial group is discriminatory. Assigning employees to a certain racial group exclusively to work in certain jobs in the company is considered discrimination. Collecting pre-employment information about race in such a way that it's available to those making hiring decisions. Asking for information that would identify race as part of the pre-employment process is not permissible. Coding applications or resumes so the interviewer knows the race of applicants is another example of illegally classifying employees. Dismissing an employee because of his or her association with someone of a different race. Learning that an employee has a biracial child and using that information to discriminate against him in the terms of the privileges of his employment is discrimination. Finding out an employee is part of an organization that supports minority rights and using that information against her in the employment process is also a violation of the law. Title VII of the Civil Rights Act of 1964 protects individuals against employment discrimination on the basis of race and color. Religious discrimination is treating a person of a group differently because of the beliefs they hold about our religion. In 1997, there were 1,709 religious discrimination complaints filed with the EEOC, with 2,137 resolutions, and reasonable cause found in 4.4% or 95 of those cases. Reasonable cause exists when the EEOC believes that there's enough evidence that discrimination has occurred to make a case. In 2015, the number of charges was more than double that of 1997 at 3,502, with 3,736 resolutions, the same cases carried over from a previous year, and reasonable cause found in 3.7% or 139 of the cases. Religious discrimination occurs in a variety of forms. An employer might have a policy that requires employees to work on Saturdays. Such a policy could have disparate impact on an employee whose religion does not permit working on Saturdays. The employer would either have to accommodate an employee by permitting him or her to work on a day other than Saturday, or prove that adjusting the schedule would impose an undue hardship on the organization. Undue hardship can take the form of diminished job efficiency, higher than usual administrative costs, impaired safety in the workplace, need for coworkers to perform hazardous or burdensome portions of the employee's work, or a violation of law or regulation. Employees may also experience religious harassment, which occurs when employees are subjected to a hostile work environment because of their religious affiliation. Another important issue for companies is the extent to which employees can express religious beliefs at work. Employers are obligated to make reasonable accommodation for employees' religious beliefs unless doing so would result in undue hardship for the employer. If an employer allows employees to keep personal books on their desk to read during breaks, the employer would have to allow an employee to keep a Bible or a copy of the Quran on his or her desk to read during breaks. Religious organizations are permitted to use religion as a BFOQ for certain positions. If a professor at a church-affiliated university is teaching a course based on religious principles, the university may specify that the person hired must be a member of the university's religion. It would be hard to make the case that custodial staff or clerical staff at the same university had to be members of that particular religion. Religious discrimination is treating a person or group differently because of beliefs they hold about a religion. We now review some of the ways in which employers have engaged in gender-based discrimination. These include gender as the basis of an employment decision, gender plus discrimination, and sexual harassment. First, employers engage in gender discrimination when they use a person's gender as the basis for an employment decision. This form is the most straightforward and obvious way that gender discrimination occurs. The second form of gender discrimination occurs when an employee would have been treated differently if it had not been for that employee's gender. This form is known as gender plus discrimination. An employer who refuses to hire women with preschool-aged children but hires males with preschool-aged children is guilty of gender plus discrimination. The third form of gender discrimination is sexual harassment. Under Title VII, any form of gender discrimination is illegal, but in 1986, the Supreme Court ruled on a gender discrimination case. This case made it clear that creating a hostile work environment for someone because of their gender was also prohibited under Title VII and was considered sexual harassment. Keep in mind that sexual harassment can involve two members of the same gender. According to EEOC guidelines, sexual harassment includes, but is not limited to, the following: unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly as a term or condition of an individual's employment, submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual, or such conduct has the purpose or effect of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or otherwise offensive working environment. The EEOC has identified two types of sexual harassment. The most straightforward type is called quid pro quo harassment. Quid pro quo means something for something, or this for that. When this type of harassment occurs, submission to sexual conduct is made explicitly or implicitly as a condition of employment. A manager might agree to give an employee a raise or a promotion in exchange for her going out on a date with him. No date, no raise. The manager's request constitutes quid pro quo sexual harassment. The other form of sexual harassment is referred to as hostile work environment sexual harassment. Hostile work environment harassment is quite controversial in some instances and more straightforward in others. The challenge arises because what may not appear to be a hostile work environment to one person may appear to be to another. Some people are offended by jokes with sexual overtones, while others are not. Whether or not employees might be offended, the jokes do not belong in the workplace. Managers have an obligation to take corrective action once they are informed of a potential sexual harassment situation. According to the EEOC, a company may be guilty of harassment if the company knew or should have known about the harassment. A manager who ignores a complaint is allowing the climate to exist that's offensive to an employee in the work unit. If the employee pursues action through the EEOC or through the courts, the question becomes whether there's a pattern of such behavior in the firm's workplace and whether a reasonable person would find the behaviors offensive. In sexual harassment cases in which the victim of harassment complains to management and nothing is done, or management should have known about the problem even if the victim did not speak up, the victim will have a better chance of winning the case. Therefore, it is important for managers to act quickly and decisively when any suggestion of sexual harassment occurs. Managers are agents of the company and put the company at risk if they are the harassers, or if they fail to take complaints seriously, or their employees tell them about possible sexual harassment incidents. The EEOC and the courts generally respond more favorably to employers who have clearly communicated to employees that behavior of a sexual nature is not welcome in the workplace. Also, employers can improve their chances of defending a case brought against them by showing that the plaintiff did not take advantage of corrective and preventative opportunities offered by the employer. If the company can prove that the incident was never reported, even though the company had a clearly defined complaint process, the company will have a better chance of defending its lack of responsiveness. The EEOC has clearly articulated basic guidelines for employers to follow to reduce the incidence of sexual harassment in the workplace. National origin discrimination involves treating people applicants or employees unfavorably because they're from a particular country or part of the world, because of ethnicity or accent, or because they appear to be of a certain ethnic background, even if they're not. National origin discrimination results from treating an individual differently from others in employment situations because of his or her ancestry, ethnicity, or accent, treating an individual differently because he or she is married or associates with someone of a particular nationality, or assuming that that person is of a particular national origin group because of physical, linguistic, or cultural traits associated with that ethnic group. The EEOC has identified a number of ways in which language requirements used by employers can lead to national origin discrimination. After September 11, 2001, many individuals of Arab ancestry experienced discrimination in the workplace. Making an employment decision based on an applicant's or employee's accent when the accent does not interfere with job performance is considered discrimination. English fluency can also result in discrimination charges, requiring fluency in English when such is not required for effective job performance. English-only rules, like having a rule that employees must speak English when it's not essential for the safe or efficient operation of the business, can lead to charges of discrimination. Race refers to a person's physical characteristics, most typically skin color. National origin, on the other hand, refers to where a person is from, or where that person's ancestors were from. The confusion is easy to make since a person's national origin is generally correlated with their race. The purpose of this act is to prohibit employers from discriminating against women because of pregnancy, childbirth, or a related medical condition. This means that an employer cannot refuse to hire a woman because she's pregnant. Nor can an employer fire a woman because of her pregnancy. Also, an employer must treat pregnancy the same way it would handle any other medically related condition or temporary disability of an employee. If an employer modified work tasks for an employee with a broken leg, a temporary disability, the employer would have to make similar temporary modifications for a pregnant employee if needed. In addition, the PDA spells out employer requirements regarding benefits. Companies' health insurance plans cannot exclude pregnancy. Employers are required to provide the same health coverage to spouses of male employees as they do to spouses of female employees. Companies have to provide the same benefits and privileges to pregnant employees, regardless of marital status, that they would provide to other employees who are temporarily disabled. The ADEA makes it illegal for an employer to discriminate against any individual age 40 or older because of that individual's age when making employment decisions. These decisions include activities such as promotions, layoffs, and pay raises. The ADEA resulted from employment practices in which employers preferred younger workers over older workers, and even terminated older workers to avoid having to pay retirement benefits to them. The Act applies to employers with over 20 employees and includes state and federal governments, employment agencies, labor organizations, as well as the federal government. Age discrimination can occur even if both individuals are in the protected class. Here's how that might happen. An employee who's age 50 is denied a promotion, and the promotion goes to someone who's 42. Both individuals are over 40, but discrimination may have occurred. The older employee would use the 4-step McDonnell-Douglas test to make a prima facie case of disparate treatment. If he could do so, the company would then need to defend its actions by establishing a non-discriminatory reason for the decision. Courts have tended to uphold early retirement incentives and waivers offered by employers as long as the employees were not coerced into signing the agreements. The agreements were presented in a way that the employee could understand, and the employees were given enough time to make the decision. The courts have also supported the use of BFOQs based on age when a company can demonstrate that age affects performance in a job and could create a risk to public safety or adversely affect company efficiency. Further, the law includes a provision for company retirement of high-ranking executives who are guaranteed by their employer a certain level of retirement income. Organizations are finding that older workers make excellent employees and are actively recruiting them for the skills and knowledge they can bring to the job. In 1990, Congress passed the Americans with Disability Act, known as the ADA, to provide greater opportunities for access in general and employment in particular for individuals with disabilities. A study by the U.S. Census in 2010, and coinciding with the 20th anniversary of the ADA, revealed that nearly 1 in 5 people in the United States has a disability. The ADA specifically prohibits employers from using a disability as a basis for discriminating against qualified individuals in making employment decisions. Qualified is a key word in interpreting the ADA and in other employment laws as well. No anti-discrimination law, including the ADA, requires an employer to hire someone who is not qualified, that is, someone who does not have the knowledge, skills, and abilities or other characteristics required to perform the job. The ADA further defines qualified in terms of individuals with disabilities. A qualified employee or applicant with a disability is an individual who, with or without reasonable accommodation, can perform the essential functions of the job. The Act was amended in 2008 following several Supreme Court rulings that many perceived diminished the intent of the original ADA. In passing the original ADA, Congress tried to be clear regarding the terms and conditions of compliance with the Act. As often happens, a number of issues were left open to interpretation. In an attempt to remove some of the confusion, President George W. Bush signed into law the Americans with Disability Act Amendments Act of 2008, known as the ADAA. The ADAA made it easier for individuals to establish the existence of a disability. A disability is a physical or mental impairment that substantially limits one or more major life activities. Individuals who have a record of such impairment or who are regarded as having such an impairment are also covered. Major life activities include breathing, walking, eating, and similar activities that are associated with being able to live and care for oneself and performing manual tasks, and the operation of major bodily function. Essential functions of the job are tasks, duties, and responsibilities that must be done by a person in a job. Must is another important word in the context of the ADA. If there is someone else who can perform the function instead of the person in the particular position, or if someone else can assist in performing the function, then it probably is not an essential function for that specific position. If the job exists to perform that function, or there is no one to assist with doing it, then the function is considered essential. The question then becomes whether the person with the disability can perform the function with or without reasonable accommodation. The EEOC defines reasonable accommodation as making modifications in how the work is done or in the work environment so that someone who is qualified for the job and who has a disability can perform the job. Reasonable accommodation is not required if providing the accommodation will create an undue hardship for the employer. In other words, an employer with limited financial resources would not be required to spend a large sum of money to make a reasonable accommodation. The EEOC notes that undue hardship is determined by the difficulty and expense of the accommodation relative to the size, financial resources, structure, and nature of a company's operations. Companies need to keep all medical information separate from other personnel records to ensure that the information remains confidential and is seen only by individuals who have an absolute need to see it. A supervisor working to make a reasonable accommodation or an emergency medical technician who is called in to treat an individual for a workplace injury would need to see the information. Title II of the Genetic Non-Discrimination Act of 2008, known as the GINA, is designed to prevent such discrimination from happening in the workplace. GNIA prohibits employers from using genetic information for making employment decisions. The Act also prohibits employers and other covered organizations from requesting or otherwise acquiring genetic information about applicants or employees. There are times when an employer may have access to genetic information, such as family medical history, but GNIA strictly limits the employer's use and disclosure of such information. In March 2014, the EEOC convened a meeting to discuss the increased use of social media and the implications of that on the laws enforced by the agency. Social media sites such as LinkedIn are frequently used for recruiting employees. The ability to learn their race, age, gender, and other information related to protected classifications of potential applicants through such sites unfortunately creates the opportunity for bias to enter into the decision-making process. The use of social media can also affect other employee decisions where bias can affect outcomes. The EEOC website, found at www.eeoc.gov, provides contact information for all district, field, area, and local offices. Individuals can also contact their state Fair Employment Practices Agency. The charge should be filed within 180 days from the occurrence of the alleged violation. The time to file can be extended to 300 days under limited circumstances. Once a charge is filed, the EEOC will review the charge and decide if it warrants investigation. If deemed appropriate, the EEOC will begin an investigation seeking to collect as much factual information as possible about the allegation. At any point in the process, the EEOC can seek to settle with the employer. If settlement efforts are not successful, and if the investigation indicates that discrimination occurred, the EEOC will try to work with the employer for conciliation. Compared to litigation, conciliation is a voluntary, less formal, and less costly process used to resolve a discrimination charge. The EEOC may also select the case for its more formal mediation program, which is a voluntary program that uses a neutral third party as a mediator and is available at no cost to the employee or employer. Like conciliation, mediation is a good way to avoid costly, lengthy litigation processes. In fact, the EEOC is increasingly encouraging employers and employees to use these techniques, known as Alternative Dispute Resolution, or ADR, to resolve discrimination complaints. ADR provides a process for resolving disputes among employees and employers using a mediator or an arbitrator, and is generally leading to more productive and positive outcomes than taking a case to court. If settlement, conciliation, or mediation efforts are not successful, the agency will decide whether to take the case to court. In the event that the EEOC decides not to sue the employer on the individual's behalf, the individual has 90 days to file a lawsuit on his or her own. The executive order we discuss here directly influences how an employer manages human resources. These executive orders require employers to do more than to not discriminate. They require employers to make a concerted effort to bring underrepresented groups into the workplace and help them advance once hired. Compliance with anti-discrimination executive orders is under the jurisdiction of the OFCCP. Executive Order 11246 was signed into law in 1965 to prohibit discrimination based on race, color, religion, sex, or national origin. In 2014, sexual orientation and gender identity were added as protected classifications. You may be wondering how this executive order differs from Title VII. Good question. In many ways, it doesn't, except that it applies specifically to federal contractors and subcontractors, most of which also have to abide by Title VII regulations. The big difference is that Executive Order 11246 specifically requires federal contractors and subcontractors to put into place affirmative action programs, which we will describe shortly. Under Executive Order 11246, federal contractors are required to do all of the following. Ensure that the job application process and subsequent employment experience are not based on race, color, religion, sex, or national origin. Conspicuously post notices from the OFCCP describing the provisions of the Non-Discrimination Clause in Executive Order 11246. Provide notices to labor unions and other groups with whom the employer has a collective bargaining agreement, and state on all job advertisements that the organization is an EEO affirmative action employer. The federal government can withhold payment to contractors that fail to comply with this executive order. The affirmative action requirement of Executive Order 11246 is very important. Affirmative action employers actively seek to identify, hire, and promote qualified members of underrepresented groups. That is, they do more than simply not discriminate. Affirmative action programs exist for one of three reasons. The first reason, which is to comply with Executive Order 11246. Second, any employer can decide to engage in affirmative action, even if not required by law to do so. Many managers understand the contributions that a diverse workforce can make to company success, and they actively seek to recruit, hire, and promote individuals from many different racial and ethnic backgrounds. This type of affirmative action program exists out of the goodwill of the employer, the belief that affirmative action is the right thing to do, and the belief that it can help the company prosper in the long run. After all, if your customer base is diverse, doesn't it make sense for your workforce to be diverse? Third, companies may have affirmative action programs resulting from a court-ordered consent decree. These decrees result from a court finding that an employer is guilty of discriminating against a protected group in its employment management practices. In such cases, the court will identify what the employer needs to correct and for how long the decree is in effect. Affirmative action plans under Executive Order 11246 are periodically reviewed by the OFCCP and require the company to engage in three activities. First, conduct a utilization and availability analysis. This analysis is a profile of a company's current workforce relative to the pool of qualified workers in the relevant labor market. Companies must first identify the demographic profile of current employees in certain job groupings, for example, managerial, secretarial, and technical. Second, companies must identify the percentage of individuals in the relevant labor market, the appropriate comparison group of skilled employees who are in each job grouping. Third, companies must then compare these two demographic profiles. For example, the company will have to determine what percentage of administrative assistants already in the company are female and what percentage of individuals in the workforce that may work as administrative assistants are female. If a company's percentage for a demographic category is considerably lower than the percentage of the demographic category available in the labor market, that protected group is said to be underrepresented or underutilized for that job group. Next, we identify goals and timetables. The next step is to establish goals and timetables to address underutilization. It is important to understand that goals are not the same as quotas. Quotas involve hiring a certain number of employees from a protected classification and are often met by hiring underqualified applicants or applicants who are less qualified than others just to make the numbers. The OFCCP explicitly bans quotas. The last step in an affirmative action program is to develop and implement an action plan to accomplish the goals established in Step 2 to eliminate underutilization in the company's workforce. Companies may use a number of tactics to provide greater opportunities to underutilized groups. Companies can modify where they advertise open positions to target certain demographic groups. Also, they can train current employees to increase the potential for promotions into job categories that are underutilized. The OFCCP reports many successes as a result of affirmative action programs required of federal contractors, including more females moving into management positions in Fortune 1000 companies, employment of people with disabilities, and minority groups entering positions in companies that might not otherwise have been accessible to them. There is a downside to affirmative action, however. Employees hired under affirmative action plans may be perceived as less qualified than other coworkers. As a result of this perception, they may end up not receiving equal treatment in the workplace. Some argue that affirmative action improves the quality of group performance and creativity and can lead to greater variety of perspectives. Others point out the negative outcomes, such as less group integration and lower organizational attachment. Another problem associated with affirmative action is reverse discrimination. This type of discrimination occurs when members of a protected group are given preference in employment decisions, resulting in discrimination from non-protected groups. However, if two parties, one minority and one not, are equally qualified and the company has an affirmative action plan, hiring the minority applicant may be appropriate. Immigrants who have the legal right to work in the United States are protected under the Civil Rights Act of 1964 national origin provisions. In 1986, Congress passed the Immigration Reform and Control Act, known as the IRCA, in an attempt to control unauthorized immigration to the United States. This law also has anti-discrimination provisions. Specifically, employers with 4 or more employees are prohibited from using national origin or citizenship as the basis for their employment decisions. This portion of the law provides protection against national origin discrimination to a group not covered by Title VII, employees in firms with 4 to 14 employees. Employers are responsible for verifying that all employees they hire have the legal right to work in the United States. Companies confirm this by having employees complete the INS Form I-9, Employment Eligibility Verification, and by collecting the specified documentation that verifies the worker's identity. To prevent discrimination on the basis of citizenship, employers are encouraged to wait until after a job offer has been made to request that Form I-9 be completed. The Immigration and Naturalization Service, INS, enforces the IRCA. Employers who hire workers who are not eligible to work in the United States can be fined, debarred from government contracts, receive criminal penalties, and be ordered by the courts to hire the individual who was discriminated against and/or give back pay to that individual. Fines can range from $110 for each form not completed to $3,200 for each unauthorized worker for the first offense and $16,000 for each unauthorized worker on the third offense. A persistent pattern of violating this law can result in up to 6-month prison sentences for the business owner. In recent years, the enforcement of this law has garnered greater attention as more focus has been placed on national security issues and as efforts have been made to more closely guard U.S. borders since 9/11. Form I-9 has undergone several revisions since it was first put into effect, including changes to the list of documents that someone could use to verify employment eligibility and clearer instructions for employers and employees. E-Verify is an internet-based system that allows employers to compare information from the employee's I-9 to data from the U.S. Department of Homeland Security and the Social Security Administration records verifying eligibility to work. This service is fast and free to employers through the Office of Homeland Security at www.uscis.gov and is currently used by over 600,000 employers. In 1993, Congress passed the Family and Medical Leave Act, or FMLA, to provide job protection for employees in just such situations. The FMLA requires employers with 50 or more employees in a 75-mile radius to grant up to 12 weeks of unpaid leave to an employee who needs to take time away from work because of his or her own illness, to care for a sick member of his or her immediate family, such as a child, spouse, father, or mother, but not including his spouse's immediate family, and for the birth, adoption, or foster care of his or her own child. Employees must have worked for the employer for at least 12 months and for 1,250 hours during the 12 months preceding the beginning of the leave. In 2008, the FMLA was amended to allow for leave for family members of soldiers who are on or about to go on active duty. Also added was the provision for caregiver leave for wounded service members. This provision extends leave eligibility to a spouse, son, daughter, or next of kin for up to 26 weeks of unpaid leave. In 2015, the definition of spouse was amended to ensure eligible employees in legal same-sex marriages would be covered under the FMLA. The Act requires prior approval for leave to count as FMLA leave. Under the FMLA, the employer can permit or even require its employees to designate vacation or sick leave as part of FMLA leave so that they receive pay during at least a portion of the 12 weeks. In addition, the leave may be taken intermittently throughout a 12-month period. Except in cases of key employees, the law requires that the employer provide the same or an equivalent job for the employee when he or she returns from FMLA leave. Key employees are those whose absences could lead to substantial and grievous economic loss for the organization. The purpose of this act is to ensure that non-career military personnel can keep their civilian employment and benefits when volunteering for duty or being involuntarily called to duty. Non-career military include individuals in the reserve units of any branch of the uniformed services, for example, the Army or the Air Force, as well as members of the National Guard. In addition, the USERRA is designed to ensure that these individuals can seek employment without being discriminated against and to encourage others to join the uniformed services non-career programs. With some expectations, the total length of time covered individuals can be absent from work and retain his or her employment is 5 years. Most employers are required to abide by the USERRA even if they only have one employee. Any individual who has served in the uniformed services has rights if that individual seeks employment after serving or was employed and took a leave of absence to perform the service. These rights affect initial employment, re-employment after serving, employment retention, promotion, and other benefits. Fair employment practice laws are state and local government employee management regulations. These laws are often more stringent than the federal government's regulations. When these regulations exist, the more stringent regulations are to be followed. If the state laws are less stringent, then the federal regulations must be followed. Differences between state and local and federal laws can exist in all aspects of the employer-employee relationship, from minimum wage to protected classifications. Managers need to be sure that they are familiar with and abide by the laws of the state in which they work. Information about the regulations for each state is readily available online from each state's labor department. Employment at will provisions give employers the right to terminate or hire or transfer employees at any time unless it's illegal to do so. Firing someone because of his or her membership in a protected class would be considered illegal. Firing someone because he or she is not performing the job or has violated company policy is allowable. Essentially, under the employment at will practice, there's no contractual obligation to which either an employee or the employer must adhere. Either party can terminate the relationship at any time for any legal reason. Wrongful discharge and terminating an employee for illegal reasons or for reasons that the courts have found to be inappropriate for discharge are known as exceptions to the employment at will doctrine or common law claims. These exceptions include the following. First, the public policy exception. An employee can sue if he or she was fired for a reason that violates public policy. That is, if his or her company acted in bad faith, malice, or retaliation. Next is the implied employment contract. An implied contract is one that is inferred, orally, written, or otherwise, by the conduct of the parties involved. Telling employees that they will not be fired as long as they do their jobs is an example. Policies printed in corporate employment manuals can also constitute implied contracts. Finally, the implied covenant of good faith and fair dealing. Employers have an implied contractual obligation to act in good faith towards their employees and vice versa. If an employee has been promised a bonus and then is fired so that the company does not have to pay the bonus, the company would not have acted in good faith and fair dealing. Employment at will, known as EAW, is a common law doctrine stating that employers have the right to hire, fire, demote, or promote whomever they choose, unless there's a law or contract to the contrary, and employees can quit at any time with or without notice.